Hi, my name's Steve Fernari, and today I'm going to show you what the ethically compliant virtual law office for non-resident attorney looks like in New York, so you can use that information to choose a virtual office provider should you ever need to do so. Before we get started, I wanted to take a minute to discuss a little bit about my background so that you have some context as to why I'm making this video and where I'm coming from. I'm a practicing corporate attorney and founding partner of the New York law firm Fernari Shear. My full law firm bio is on this page, and I'm pretty easy to find on the interwebs. I'm also a founder of a company called Law Firm Suites. We operate a shared law office spaces for lawyers exclusively, kind of what the tech folks now call a co-working space. And at Law Firm Suites, we rent virtual law office to close to 200 law firms at 2 New York City locations. But I'd like to let you in on a little secret. In 2011, I moved from New York to Florida. My law firm's bricks and mortar offices are now in Florida, but we use a virtual law office in New York at Law Firm Suites Financial District location. So I too am a non-resident virtual office lawyer, and both as a proprietor and a purchaser of virtual office services, I'm keenly interested in the ethics of virtual law office in New York. So the driving force behind virtual office ethics in New York is Judiciary Law Section 470, that says that all lawyers practicing in New York must have an office for the transaction of law business. And under the law, for New York residents, that office can be in their homes. So in essence, any resident New York attorney can use their home to comply with Section 470 and can use any type of virtual office, including a mail drop, for local business presence as long as they're not misleading clients. But for non-residents, they're left with the trouble of figuring out what an office for the transaction of law business is, whether a virtual law office meets that definition, and what complicates matters is that there's no explicit guidance from the legislature about what constitutes an office. New Jersey resident and New York licensed attorney Ekaterina Schoenfeld wanted to practice law in New York, but for economic reasons didn't want to open any physical office there, not even a virtual law office. She sued the state a few years ago, alleging that Judiciary Law Section 470 violates the Privileges and Immunity Clause of the U.S. Constitution. Her motion for summary judgment was granted in the federal district court. The state appealed, and an opinion is expected on this case very soon. I recently had the privilege of sitting on a panel discussion with Ms. Schoenfeld at a New York State Bar Association CLE webcast. As was referenced by Ms. Schoenfeld in the presentation, Judiciary Law 470 was deemed unconstitutional by the Northern District of New York, and the state didn't seek a stay pending appeal, so technically Judiciary Law 470 is not good law. However, there have been several examples where state courts are still enforcing Section 470, which can cause complications for attorneys and their litigant clients. So the recommendation from the panel was for litigators to continue to comply with Section 470 requirement until the decision comes down on the Schoenfeld appeal, but that attorneys with practices limited to transactional matters should be fine to practice from a different jurisdiction without a Section 470 office. So if you're going to comply with Section 470, let's see what the ethically compliant virtual office looks like for non-resident attorneys. In the absence of legislative guidance, I've built my profile of a Section 470 compliant virtual office from 3 resources: case law, New York State policy statements on the issue, and formal ethics opinions. The courts in New York have generally taken a pretty liberal view about what constitutes an office. Offices have included a family member's home, a hotel, a shared office space, and when the courts have talked about features of an office, they've discussed desk space, even if it's shared, mail and call forwarding, and this is really important because it's okay to have those services done by people who are not employees of the lawyer's firm. If you take a look at New York State policy statements, and I pulled those from the state's first appellate brief in Schoenfeld, where the state defended the Section 470 office requirement on 3 policy grounds. First, the lawyer should be able to receive in-state service of process. Second, they're available for contact by interested parties. And third, they're available for court proceedings. Now, in a subsequent brief, the state backed away from items 2 and 3 for obvious reasons, because given today's technology, you no longer need an office to be available for the types of things that they wanted. The last resource I used is formal ethics opinions, and there are several of them out there, but one that's most directly on point is the City Bar's Formal Ethics Opinion 2014-2 on the ethics of a virtual law office. You can essentially boil that opinion down into three features that the bar seemed to recommend. First was a receptionist who can handle pop-ins or receive packages on behalf of a lawyer when they're not in the office. A private place to have confidential meetings when needed. And third, having a staff that's trained on client confidentiality and attorney-client privilege requirements. And in the absence of a training program by the vendor, that the attorney should train the vendor's staff themselves. So to connect the dots between the three resources, I built two profiles on the ethically compliant virtual office for non-residents, one for attorneys with a little bit of risk tolerance, and another for those with no risk tolerance. Now, it's important to note that the argument that you'll be making in support of using a virtual law office as your Section 470 office in New York is that the virtual office has all of the features of a traditional office. It's just purchased using on a different, perhaps unbundled, call it, economic arrangement. So generally, you want to make sure that your virtual office, in fact, functions like a working law office. So starting with the former, for those with some risk tolerance, from the ethics opinion, we would want to have a receptionist or staff to greet guests and handle pop-ins, a process for identifying priority deliveries and notifying the attorney that they have arrived, a staff training on privilege and confidentiality requirements, or a willingness to let the lawyer train the staff on these issues. And finally, from the ethics opinion, private places to hold confidential meetings when needed. Now, from the court cases, since there's some overlap between the ethics opinion and the court cases, the recurring themes seem to be the availability of desk space. So I would say floating desk space, even in a co-working type of arrangement, would suffice. And finally, from the policy statements, it was pretty clear that the state wants lawyers to be able to receive in-state service of process in their Section 470 office. So, since the lawyer is not going to be there all the time, a willingness to have someone in the office serve as agent for service of process when you're not there would be important. Now, for the lawyers with no risk tolerance, I've added 3 additional items that come up in different jurisdictions that have a more restricted definition of office. And these include a permanent desk space as opposed to a floating one, even if that permanently assigned desk space is shared with others. Secure storage to leave items behind, and that could be personal items or marketing materials, and it could be as simple as a locking drawer in a desk. And finally, signage. So just a side note, it's very likely that any day now, a decision is going to come down in Schoenfeld that could make the Section 470 office requirement unconstitutional. So just so you don't feel like that this presentation is a colossal waste of time, should you, for business reasons, choose to have a local business presence in New York by using a virtual office, most of these features are things that you would want to look for in a vendor to have in order to minimize malpractice risk in a shared law office space and meet the ethics requirements other than Section 470. So that about wraps it up for me. 2 final things. You can download this slide deck by going to lawfirmsuites.com/470. And if you'd like to learn more about Law Firm Suites virtual office programs or visit our website at lawfirmsuites.com, we have 2 offices in New York City, and we'll be opening new offices throughout New York State in 2016.